when you are. All right, welcome everyone. It is 6:07. I am calling the meeting to order and handing it over to Judge Kakavis. Thank you.
Thank you. Okay, good evening. I am Elena Kakavis, the hearing officer presiding over this matter, and this is the matter of the Board of Education of the Greenburgh Central School District versus Terry Williams, and it is a proceeding for misconduct brought pursuant to Education Law, Section 1709, Sub 18. The appearances remain the same as on the prior days of hearing. At the conclusion of the last day of hearing, we heard the completion of the district's case, and the district rested subject to rebuttal. We'll now proceed with Mr. Williams's presentation of his case. Mr. Williams, I remind you that you had already delivered your opening statement, so we'll proceed directly with your calling of witnesses. And I just also want to remind you that we are still in the fact presentation stage of these proceedings. And that means that what you're doing now in presenting your case is you are presenting for the record facts, which you will then use in the next stage, the closing stage, to make your arguments, okay?
Yes. Just one question. Are we, if I close today, will we go to closing statements today?
Well, I will ask you and Mr. Mulholland what your wishes are with respect to submitting a written brief or an oral summation. And you can each make that decision, although typically if one side requests to do it in writing, then the other side does so as well. I will also tell you it is also always my preference for written briefs because it gives the parties an opportunity to collect their thoughts and kind of think contemplatively of the evidence that's been put in the record and present your arguments on paper. But we can talk about that when you tell me that you are done with any witness presentation that you have, and Mr. Mulholland tells me that he does not have rebuttal.
Sure. Okay, great. Thank you.
Okay, so if you're ready, then I would invite you to call your first witness.
I'm ready, and I call Adam Kleinberg, who I think you have in the waiting room.
I do, and I'll ask Ms. Kraus to admit him. Okay, and I see him there. All right, so Mr. Kleinberg, I would ask you to raise your right hand.
Sure.
Do you swear or affirm that your testimony will be the truth?
I do.
Okay, and would you just state or spell your name, please? State and spell your name for the record.
Sure. Adam Kleinberg, Kleinberg.
Okay, and I will just offer you a couple of instructions. Can you affirm for me that you are testifying from a space in which you're alone?
Yes, I'm alone. Some of my family is in and out of the house, so if there's some noise in the background, I apologize. But right now, I'm quiet. Everything's fine.
Okay, and I will instruct you also to make sure that when you testify, you're testifying from your recollection. So please don't refer to any notes or records or cell phone and nothing else. That, you know, the testimony should be your own. If you don't remember something, you can simply state that. If you are not sure, you can state that. There's a mechanism by which we can kind of help you refresh your recollection if that's needed on a particular point. The other thing is to remember to listen very carefully to the questions that you're asked. The types of questions which Mr. Williams will ask you on direct will be a little bit different in form than the questions which Mr. Mulholland will ask you. So just listen carefully and answer them as directly as possible, okay?
Okay.
All right, thank you. Whenever you're ready, Mr. Williams.
Excuse me.
Go ahead,
Yeah.
Ivy.
I'm sorry to interrupt. Mr. Lewis is the gentleman that's recording, live streaming this meeting. He just texted me he needs a second.
Okay.
I don't know if he's having technical difficulty or what. He didn't explain.
That's no problem. Yes, fine. Okay. All right, Mr. Williams, are you ready to begin?
I am, thank you.
Okay, please
We
go.
lost Tracy. Does that matter?
Oh. I mean, we can proceed without, although, oh, I
Oh,
see.
wait, I think, all right, I'll be quiet.
He has
No,
a, yeah.
I saw somebody coming near the camera. Why don't we give it just a minute? Or perhaps somebody can text her and see.
I'll text.
I think she's back, Judge.
I think we're ready.
Okay.
All right,
So,
go ahead, Mr. Williams.
so Mr. Kleinberg, thank you for appearing and thank you for coming back again. I know you waited a long time on the first day of the trial, and I apologize for not realizing that you were there and not advising you that you could go.
No problem.
Can you tell us what is your relationship to the Greenberg Central School District?
Sure. My firm was appointed by the district's insurer, NYSER, which is short for New York Schools Insurance Reciprocal, to represent the district with regard to a notice of claim. That was the source of my retention in 2020.
Thank you. Are you also a school board trustee?
I am, sir.
Okay, and what school district is that?
Half Hollow Hills Central School District in Suffolk County, where I live.
Okay, great, thank you. So you mentioned a notice of claim that you were appointed to represent the school district on, right, regarding?
Correct.
Hold on for 1 second, I'm sorry, folks. Thought I had a pen that worked. Okay. This notice of claim, was it in response to Dr. Ronald Valenti's allegation of, quote, unlawful discriminatory practices relating to employment?
Just to be clear, I have been appointed to represent the district in 2 matters, both notices of claim, but I do believe that sounds accurate. I don't have Dr. Valenti's notice and claim in front of me, but that sounds accurate.
Okay, all right. Let me ask you this, as both in your capacity as an attorney and also obviously as a school board member, can a Board of Education discuss an item or issue from an earlier executive session in a subsequent executive session?
Objection.
Basis.
This calls for Mr. Kleinberg's expert opinion, Judge. You've ruled on this, and I don't want to see Mr. Kleinberg impressed into service as some sort of retained expert for Mr. Williams. He is the school board's attorney. His mental impressions, work product, opinions, all of that belong exclusively to Mr. Kleinberg and the school district. And he should not be coerced into revealing what those impressions might be for the benefit of Mr. Williams. If Mr. Williams wants to retain a legal expert to present as an expert advisor, he can do that. But I cannot sit here and ask and watch the school district's lawyer be used in that way. So I object.
Mr. Williams, you want to be heard?
Yes, thank you, Your Honor. Mr. Kleinberg is an expert. He is an attorney. I'm merely asking the attorney's opinion of which he's qualified to give, given his profession and also his role as a school board member, about what is appropriate or what is legal with regard to executive session.
You want to respond to that, Mr. Mulholland? Or I'll make my ruling.
I don't believe I need to, Judge. Again, this is covered by your ruling on the motion in limine. I think this is squarely within the ambit of that motion and your ruling. I object.
Yes, the objection. Go ahead, Mr. Williams. You want to say something else?
Yes, I do recall you making a ruling as it related to somebody who was not an attorney when I asked that question. And the basis of Mr. Mulholland's objection was the fact that that person was not an attorney. Mr. Kleinberg obviously is an attorney, and again, the question is at a high level and just asking about what can and cannot be said or done in executive session.
Mr. Williams, the motion in limine addressed testimony being elicited from anyone who has represented the board with respect to soliciting legal advice that to which the board may have been privy or which would have been given to the board. So I'm sustaining the objection, and I will continue to make that ruling as to any legal advice solicited or attempted to be solicited from someone who has been in a representative capacity.
Sure, okay. Mr. Kleinberg, so you were assigned to represent the board. Yes or no, did you meet with the board collectively on this topic?
Objection, Judge.
Basis?
I object to Mr. Williams conducting a cross-examination of this independent neutral witness who he has hailed into the hearing room. He should be asking open-ended questions and not grilling the individual witness as if it were a hostile witness.
Mr. Williams, he's objecting to the nature of your question, the yes or no format, which is typical for the cross-examination. This is your witness. This individual has not been identified as a hostile witness as of yet. So just rephrase your question, and if it is leading, it's going to be objected to, I'm sure, again. So ask open-ended questions, please.
Sure, okay. Let me just find my question again. Did there come a time, Mr. Kleinberg, that you met with the school board to advise them on the notice of claim that we're discussing?
Yes,
And also, did there come a time where you met with each board member individually on this notice of claim?
yes.
Okay. Do you recall how many times you met with the school board collectively on this notice of claim?
I'd like to say 3, but
Oh.
I would need to, go through my records on that.
Sure. Did you talk or meet with me as part of this notice of claim?
Yes,
During that meeting, did you ask me what occurred on April 7th?
Judge, I'm going to note that I have no objection to that question as a simple yes or no, but I'm getting very close to needing to object. The questions that Mr. Kleinberg framed during any interview with the board member reflect his mental work product and should not be probed into, not openly in this public hearing, not at all by someone other than the board itself, if it chooses to go into that and waive the privilege.
Mr. Williams, do you understand that objection?
I understand the objection. So the question that I asked, yeah, I understand his objection. So you know what I'll do?
It was an anticipatory objection. The
Right.
question as to whether you were asked what occurred on April 7th was not objected to by Mr. Mulholland. That's okay, but he is anticipating that you may be intending to go into the substance of discussions had between an attorney hired by the board to represent the board and individuals who were meeting with him in the capacity as board members. And he is asserting a privilege in that regard. Okay, so be
Right.
mindful.
I understand that. And I guess I would add, in anticipation of his objection, I'm not going to ask Mr. Kleinberg about any discussions that he had with the board collectively. I'm just going to ask him about the conversations that he and I had.
Well, we'll let Mr. Mulholland respond to those accordingly.
Sure.
So
Okay.
The witness can answer the question as to whether he asked what occurred on April 7th.
Just to be clear, I'm presuming April 7th was the date of the board meeting at issue.
Mr.
Yes.
Williams, reframe your question, Mr. Williams, for the record.
Yes. Did you ask me what occurred during the April 7th board meeting that was the subject or led to the notice of claim?
Yes, I asked about what was in the notice of claim.
Okay. What did I tell you about? Let me rephrase this. During our conversation, did we discuss the use of the Zoom technology?
I
Yes.
object, Judge.
Sorry.
No,
I didn't-
Just a second, basis?
Well, again, I think that this starts to get too close to the substance of the discussion that Mr. Kleinberg had. I also object to Mr. Williams trying to use Mr. Kleinberg as some sort of subterfuge to giving his own testimony. If Mr. Williams wants to testify, he can. I think it's inappropriate to try and indirectly get in what Mr. Williams may believe, may want to argue, or may recall as the facts through another witness.
Well, Mr. Williams, do you want to be heard?
Yes, thank you, Judge. This is the evidence that that the board has entered into this hearing. So all I'm doing is just gathering another perspective on the exhibit that they introduced.
What exhibit are you specifically referring to?
Oh boy, I think it's exhibit 8 or 9 of the board's exhibit, the one in which they entered Dr. Valenti's complaint alleging discrimination. As Mr. Kleinberg said, the notice of claim.
Yes, that is in the record, Mr. Williams. Mr. Mulholland is correct that you will have the opportunity to testify. And in fact, you'll have the opportunity to testify by way of a narrative because you are representing yourself. And your testimony as to what was discussed, to the extent there are not objections as to privilege, is able to be had on the record. The concern here, although the question, did we discuss Zoom, is not in and of itself problematic. The concern here is that there are a few privileges that are more highly protected than the privilege between an attorney and a client. And again, this individual, Mr. Kleinberg, was representing not you individually, but representing the board, hired to represent the board. And you are coming close to asking questions about the content of your discussions as a board member with Mr. Kleinberg as counsel to the board. So I'll allow the question about Zoom to be asked, but you need to rethink the nature of your questioning, because I'm sure we're going to continue to get objections. And as we get closer to privileged information, I'm going to have to sustain them. So Mr. Kleinberg, you can answer the question about.
I believe I said yes.
Okay.
During our conversation, Mr. Kleinberg, did I say to you at some point that I was unaware that Dr. Valenti was in the Zoom call?
Objection.
Basis stated for the record.
Judge, this is a highly privileged conversation going on. If we're going to get into parts of it that might suit Mr. Williams' purposes, then we're going to need to get into the whole thing. It's really an indirect means of subverting the entire privilege and putting me in the compromised position of needing to choose between divulging an entire privileged conversation reflecting all the work product, opinions, and mental decisions by Mr. Kleinberg on behalf of the district, and perhaps not just during this interview, but during the interviews with all the board members. It's a Pandora's box we cannot open, we cannot shut once it's open, Judge. I believe this privilege needs to be respected.
Yes.
Judge, if I may,
Go
if I
ahead.
may respond, yes. So I would argue that, like the first question that I answered, asked and answered by Mr. Kleinberg, it got close to the privilege, but it did not cross the line. This question, I believe, does not cross that line either. And Mr. Mulholland has he has the ability to object when that question or when a question crosses the line. I don't think asking him, certainly the first question didn't cross that line as you allowed that to go forward. I don't think this one crosses the line, but I would say that I'll ask the question, and if it crosses the line as to privilege, you can obviously in your capacity say sustain it or overrule it.
Okay, well, I think it crosses the line, so the objection
Okay.
is sustained.
Okay. Did I attribute, Mr. Kleinberg, did I attribute my lack of awareness? I'm sorry, let me take that back. During our conversation, do you recall if I mentioned to you that I was still getting used to using the Zoom technology?
Objection.
Okay, Mr. Williams, what's happening is by way of your leading questions, you are in effect testifying through the witness, and you are right in the middle now of substantive conversation. So I'm going to direct you to move beyond any conversation you had with Mr. Kleinberg in his capacity as counsel to the Board of Education.
Okay. Mr. Kleinberg, does executive session provide board members protection against discriminatory language?
Objection. Calls for mental conclusion, work product, attorney-client privilege. Previously stated grounds apply here, Judge.
Same ruling as before, Mr. Williams.
Sure, okay. Mr. Kleinberg, what are some of the reasons that an attorney might recommend that a board settle a complaint?
Objection. Same grounds, Judge.
Sustained, Mr. Williams.
Okay. Judge, I have no other questions of Mr. Kleinberg.
Mr. Mulholland, any cross based on that very limited direct?
No, Judge.
Thank you, Mr. Kleinberg. I appreciate you being online.
Thank you. Have a good evening. Take care.
Thank you. Okay, Mr. Williams, another witness?
Yes, I call David Warner.
Mr. Warner, would you please raise your right hand? I know I administered the oath during the last session, but I will re-administer it now because of its importance. You swear or affirm that your testimony will be the truth.
Yes.
Thank you. Whenever you're ready, Mr. Williams.
Yes. David, during the finalist interviews, did we learn of material information concerning one of the candidates had been withheld by the search consultant?
Yes.
Do you recall the, let me rephrase. Should that, in your opinion, should that information have been shared with the trustees?
Yes.
Had you known of that information prior to the scoring that we used in evaluating the trustees, might that have changed your score of that particular candidate?
It might have.
Would it have increased the score?
No.
It might have decreased the score.
Yes.
And the ranking of the candidates was based on a cumulative score. Yes or no?
Yes.
So if it might have reduced, if that information might have resulted in you reducing your score, that could have potentially eliminated a candidate from contention.
Possibly.
Possibly. Thank you. Excuse me. Did there also come a time during the candidate interviews? Oh, excuse me, let me back up. And who was responsible for whether or not this information, who was responsible for this information not being passed on to the board?
Gray and Associates.
And who in particular from Ray and Associates, please?
That's not clear.
Excuse
I
me?
don't know. I
You
don't
don't
know.
know.
It could have been anyone. Could have been Mike.
Who was our search consultant? Who from Ray and Associates was our search consultant?
I don't remember.
Was Dale Caldwell our search consultant?
Dale Caldwell was one of our search consultants.
Was Dale Caldwell the person who managed the interviews and was in contact with us regarding the finalists and the other candidates after the initial meetings?
Yes.
Okay, thank you. Did there come a time also during the interviews that I asked Mr. Caldwell about another candidate's, do you recall, I should say, that I asked Mr. Caldwell about another candidate's resume and the fact that the candidate had both deputy superintendent and assistant superintendent listed on there?
Would you repeat your question?
Yes, sorry, that was very long. Actually, if the reporter could repeat it for me.
Reporter, read it, please.
Did there come a time also during the interviews that I asked Mr. Caldwell about another candidate, do you recall, I should say, that I asked Mr. Caldwell about another candidate's resume and the fact that the candidate had both deputy superintendent and assistant superintendent listed on there?
You understand the question?
Yeah.
Okay, I'm sorry. Do you understand the question or is that the answer?
I recall you asking some sort of question like that. I don't recall the answer.
Do you recall that Mr. Caldwell said that the candidate explained that it was a lateral move?
Certainly.
In the hierarchy of school board, not school board, in the hierarchy of executive leadership in a school district, is the superintendent the number one spot?
Yes.
Is the deputy the number two spot?
I am unfamiliar with that terminology. We don't have an assistant and a deputy in our size of school district, so I probably had to look it up at the time.
Do you know, you're unfamiliar because we don't have it, right?
Correct.
Do you know of other school districts if they have it and if that is the hierarchy?
Apparently other school districts do have it, or we wouldn't be talking about this topic.
And in your knowledge of other school districts, is the deputy typically the number two person?
Jackson Foundation.
Yeah, Mr. Williams, I'm not sure that this witness is really able to answer this. He said he really wasn't familiar with it and he looked it up, but I don't think he has the basis to testify.
Sure, okay. Did there also come another time, David, that you asked Mr. Caldwell about another candidate and the fact that that candidate had not been a superintendent of a K through 12 district?
Yes.
Was that information something that was problematic for you?
Yes.
Is that something that you would have expected the search consultant to provide to you early on in the process?
Yes.
Would you agree that, let me rephrase, please. Okay, thank you. Taken together, David, the withholding of the material information that we talked about at the start, and the lack of clarity or the lack of transparency on the other candidate's district, would that qualify as good due diligence on the part of the search consultant?
No.
Okay, thank you. Thank you. So if it is not good due diligence on the part of the search consultant, would it be reasonable for a school board member to express dissatisfaction about that?
Yes.
Okay, thank you. Judge,
Yes.
I have a few exhibits that I would like to enter that I neglected to send. How should I handle this?
You haven't sent them to anybody, Mr. Williams?
I haven't sent them to anyone, no.
Okay. Why don't we take a 5-minute break, and you can send them to Mr. Mulholland. And when we come back on, we'll mark them and identify them. He if he's kind enough to send them to the text so they can be screen shared, and then we'll entertain any objections and determine if they'll be entered into the record.
Okay, great, thank you.
So how many do you have? Will 5 minutes be sufficient?
5 minutes will be more than sufficient. It's 3. And I actually had them teed up, but just forgot to send them.
So send them to Mr. Mulholland. Is that okay with you? You'll get it by email?
Yes, Judge.
Okay, thank you. We'll be
You could
back.
if you could include my colleague Brianna on that. She's been on the other emails. That would be very useful.
Yes, of course. Please do so. It's 6:42. We'll come back on at 6:50.
Should I, before you go, Judge and Mr. Mulholland, should I also include Darlene Philbin or just?
That's my secretary. Yes, Judge, that would be great.
Yes, please. Anybody who has previously been on Mr. Mulholland's email.
Okay.
Okay?
Yep.
All right, we'll be back at 6:50. Thank you. Okay, do we have our reporter, Mr. Morello? We're missing a few people. Okay. Okay, we'll go back on the record. Mr. Mulholland, were you able to share those with the text so that they can be screen shared?
Yes, my secretary sent them to the tech judge.
Okay.
I'm still waiting on them, Judge. I haven't received them yet.
They have been sent, Judge.
Thank you.
Okay, I'm downloading them now, Judge. Give me 5 seconds to load them up.
No problem. Thank you. Let the tech know which it is you'd like him to put on the screen.
Oh, no, not yet. I'm not ready to put it yet.
Okay,
It occurred to me. David, so we're back on the record, Your Honor?
Yes, we are.
Okay, so David, let me just back up again and talk a little bit more about the search process and the performance of the search consultant. David, do you recall that I inquired about when we got to the finalists, the round with the finalists? Do you recall that I inquired about the candidates' evaluations?
No.
Okay. Well, that eliminates a lot of questions. Okay, so on February 23rd, I emailed the two finalists information about the climate in Greenburgh Central School District, and that's That's board exhibit number 32. If the tech could put that one up, that's not one of the ones that I sent you, but it was board exhibit number 32.
Okay, please put that on the screen if you can. Is that the document you intended, Mr. Williams?
No, I'm sorry. I meant exhibit number 33, board exhibit number 33.
Tech, please move to that. Thank you.
So David, do you recall seeing this email?
Yes.
Okay. And at this point, have you read it?
Not in the past few minutes, but I've read it before.
Okay. All right. I just want to make sure you read it. Question for you. Is including in this email, is the inclusion of the petition signed by 600 people an example of me disparaging the board?
No.
Okay, thank you. Is including a story that ran in the Journal News about the board's vote on the superintendent's contract, is that an example of me disparaging the board?
No.
Okay. Is the inclusion of Dr. Chase's redacted evaluation in which she was rated effective an example of me disparaging the board?
No.
Excuse me, folks. That's the, I don't know if you could hear that. That's some young fellas with some loud cars. I'm just gonna wait a moment.
Okay.
Okay, great. Is my including emails with no context of board interact, is my inclusion of emails that did not include any context, but the emails were of board interactions with the superintendent, an example of disparaging the board?
Yes.
Did the dialogue in those emails actually occur?
Yes.
So I did not add anything to those emails.
Correct.
So those were indeed conversations between board members and the superintendent.
Correct.
Were those emails marked as confidential?
I do not recall.
Okay. So I sent this email to the two finalists informing them of the climate on February 23rd. And later that evening, we interviewed them. Do you recall?
Yes.
Okay. And later that evening on the 23rd, the board voted to extend an offer to enter into contract negotiations with Dr. O'Hara.
Correct.
Okay. Now, do you recall on 2 days later, on the 25th, that President Darden Cintron sent an email from Dale Caldwell in which Dr. O'Hara said he was excited about becoming the next superintendent? That would be Exhibit 41. I'm sorry, Tech, for giving you the late notice. That would be my Exhibit 41. And if you could scroll,
Judge, this exhibit is not in evidence.
Yes, no.
oh, okay,
The next exhibit, Mr. Williams, would be Respondent's Exhibit 39. Okay, so why don't you, if you want the tech to put this document that you're talking about up on the screen, we could mark it for identification,
sure.
and then we'll see where it goes.
Okay. Tech, if you could put exhibit number 41 up on the screen, please.
Okay, Mr. Williams, it's going to be Exhibit 39. Why don't you tell the tech what the document is that you want him to put up?
The one, Judge, I want him to put up the one I think I've labeled as 41. Are you saying I can't go out of order?
I'm saying that the next exhibit would be marked as 39. So, I mean, if you've randomly marked it as 41, for the purposes of telling the tech which document it is rather than describing it, but it's going to be marked as Respondent's Exhibit 39.
Okay, all right, okay,
We just need to get the document on the screen.
sure. So this is the one that I sent to the tech or to Mr. Mulholland as is exhibit 41, but it is for the purposes of this exhibit 39.
Okay, Ted, do you know that document? Could you put that up on the screen, please?
He has it up on the screen, Judge.
Okay, so the record should reflect that I'm marking as Respondent's Exhibit 39, what appears to be an email dated March 3, 2021 from Ms. Darden Cintron to the board. And also attached at the bottom is an email which apparently came from Dal Caldwell dated February 28, 2021 to the board. Okay, now, Mr.
You know what? I think actually, if you could scroll down to the end, to the bottom, Tech.
The bottom of the first page or the last page?
The last page, please. Okay, and come up a bit until we have a little bit more. Okay, so this is the page. So David, do you recognize this email from Dale Caldwell about Dennis O'Hara saying he's excited about becoming the next superintendent of our school district?
Judge, I just want to note this is not in evidence yet.
Yes, okay, Mr. Williams, we've identified the document. Why don't you offer it into evidence?
I would like to offer this into evidence.
Okay, Mr. Mulholland, any objection?
No, Judge.
Okay, so moved. Now you can question the witness about it.
Thank you.
Yes, I recall this document.
Okay. So, David, okay, so I'd like to, okay, Tech, you can take this one down, thank you. And I'd like you to put up on the screen board exhibit number 34. Thank you. David, do you recall seeing this email?
Yes.
Okay, thank you. So this email is dated February 23rd at 11:59 p.m. Dr. O'Hara thanks Dale Caldwell, and he's looking forward to speaking with Antoinette next week. And then on the 25th as was noted in my exhibit 39, he said he was excited. 2 days later, he was excited about joining us. He had already learned of the board's vote and he was excited about joining us. So he was ready to, would you agree, David, that Dr. O'Hara was ready to negotiate a contract with GCSD with the full knowledge that I had already sent him an email describing our environment?
I would agree that at the point that this was sent to us, he had already received the supposedly poison email.
Okay. Would it be reasonable to assume that O'Hara didn't view the information in my email as a deal breaker?
Objection.
Basis?
He's asking Mr. Warner to speculate about an individual who's not here, who's not testifying. I don't see how Mr. Warner can do that unless he has a crystal ball or he's clairvoyant. I think it's an inappropriate question.
May I respond,
Yes.
Judge?
Yes.
So I didn't ask Mr. Warner about, did he think about, I didn't ask him for his opinion about or his assumptions of what O'Hara thought. I asked him if you know what, Judge, I'll rephrase if I may.
Okay, go ahead.
So David, Dr. O'Hara expressed his interest in the position, in moving forward with the negotiations, even after receiving my.
Asked and answered, Judge.
That has been asked and answered.
Okay. So David, we subsequently had a meet and greet meeting with Dr. O'Hara on March 4th. Do you recall?
Yes.
Okay. Do you recall that at that meet and greet meeting, he inquired about you and myself changing our votes?
Yes.
Did you have a subsequent conversation with Dr. O'Hara?
No.
Okay. Do you recall him asking to have a conversation with me?
Yes.
And you don't know if he and I had that conversation?
Correct.
Okay. But at that time, he was the board's choice as superintendent.
Yes.
Would Dr. O'Hara, would Dr. O'Hara would he have still been appointed if you or I did not decide to change our votes and everything else remained the same, would he have still been appointed by a 5-1-1 margin?
Yes.
Would a 5-1-1 margin result in his appointment as superintendent?
Yes.
So any actions, okay. Okay, do you recall on March 13th that Dr. O'Hara wrote to Antoinette saying that a lack of cohesion led to his decision to withdraw from consideration?
Yes.
Do you recall that he cited the 5-1-1 vote to enter, that he cited the 5-1-1 vote as his reason?
Yes.
Did he already, so the date of that email was March 13th. Did he already know about the 5-1-1 vote?
Yes.
So is that contradictory when he cites the vote as a reason to decline moving forward?
Objection, Judge.
No.
Wait, don't answer. Mr. Mulholland, go ahead.
He's asking the witness to build an argument rather than making it himself on his closing statement. It's inappropriate.
Yes, Mr. Williams, the witness isn't really in a position to answer that, but that is exactly the type of thing that we discussed earlier, where you can use whatever facts you want to fashion arguments.
Okay, thank you. David, you've been on the board for about 15 years?
14.
14. How many superintendent searches have you participated in?
On Smalls. 3.
3.
Well, 4 now.
On average, would you say that it takes about 3 months to do a search for a superintendent?
Yes.
Would that be a quick search?
Yes.
Okay. If you, Tech, if you could put up exhibit, it's the one that I called number 39, but it's in essence going to be number 40 so that we can enter it into evidence. That's the news story from the Nassau Daily Voice.
Okay, let the record reflect that I'm marking as Respondents Exhibit 40, what appears to be an article titled Long Island School District Names New Superintendent, dated April 22nd, 2021.
Judge, may it be heard on this?
Yes, go ahead.
Yeah, Judge, we object to the introduction of this news story. It's dated on its face, April 22, 2021. Mr. Warner is not mentioned in this news story. I've read it since receiving it from Mr. Williams within the last half hour. It is about events that took place over a month after the events in question, and whatever arguments Mr. Williams is going to try and build from this document using Mr. Warner as a mouthpiece. Again, Mr. Warner never having, not being mentioned in the article, it not being about Mr. Warner. I think it's inappropriate for Mr. Williams to use any witness to build arguments. Plus, on top of that, the article itself is about Dennis O'Hara, who I know was previously identified as a witness by Mr. Williams. He's not within the list of the final 2 witnesses that Mr. Williams is telling us he's going to call. So that means he's going to try and introduce statements perhaps attributed to Mr. O'Hara months or over a month after the events in question without having Mr. O'Hara here to explain a statement in a news article, perhaps taken out of context. I think it's inappropriate.
Mr. Williams, what's your reaction?
Yes, I don't even know where to begin. I mean, certainly, I'm not asking, Mr. Mulholland can't know what questions I'm going to ask Mr. Warner. So that was speculative. The fact that I had Mr. O'Hara as a potential witness and then withdrew him as I see it, has nothing to do with this. We are talking about Dr. O'Hara because he was under consideration for our school district. Part of the reasons for the board's attempt to remove me is they are citing that my actions resulted in his decision. I am just merely showing that perhaps there were some other decisions here, and I'm just providing evidence of Dr. O'Hara's decision.
Yeah, and Judge, if I could be heard, the key word in what Mr. Williams just said, which really reveals everything here, is perhaps. He wants to put a news story out as a piece of evidence because perhaps it means something. Well, perhaps it means a lot of things, but without Dr. O'Hara here to explain exactly what went on in April after he moved on and was no longer interested, by his own words, in working for Greenberg, it's all speculation, Judge. And I think the only way you could get to the bottom of that appropriately would be to have Dr. O'Hara here. But frankly, the events of April are irrelevant to what Mr. Williams is charged with having done in February.
Okay, Mr. Williams, the article, I understand you are offering its relevance because it references Dr. O'Hara's path after he turned down the district position. You understand that if it is admitted, it would be admitted for the fact that it was published, but not for the truth of what it contains. Do you understand that?
Not exactly, Judge.
Well, a newspaper article, we can't assume the truth or the accuracy of the facts contained in the article. If the document comes in, it would just be for the fact that there was an article to this effect. The first question is whether or not the witness has even seen it, because there's something called a foundation that you need to lay for it. Now, I understand Mr. Mulholland's objection. I think it goes most appropriately to relevance. However, I don't want to constrain you too much in presenting your defense. So if the witness is familiar with this article, I will let it come into the record, but you need to understand that, as Mr. Mulholland points out, the best evidence would have been the testimony from Dr. O'Hara. I understand that that is not something you planned or were able to present. So the article would simply be entered in for the fact that there was an article published to this effect, not for necessarily the truth of what it contains, okay?
Okay.
All right, so if you want to ask the witness if he's even seen this, because if he doesn't, then it can't, if he hadn't, then it can't come in through him.
Sure. So, David, have you seen this article?
I have not.
Okay, thank you. All right. So, I'm going to switch topics here. David, yes or no? Well, let me rephrase that. David, is it your recollection that that I use the raised hand feature on Zoom more than any of my colleagues when we are at meetings?
Yes.
David, is it your recollection that Tracy Mayers and Cora Carey interrupt board meetings, interrupts board members and administrators more than anyone else during our board meetings?
I have not done a count. I suspect so, but I cannot confirm it.
Okay, thank you. Would you say that they do a lot of interrupting at our board meetings? Thank you. Is it your recollection that President Darden Cintron rarely stops them when they interrupt me?
Is that a yes or no question?
No, I didn't ask it as a yes or no question.
All right. So what happens is other people attempt to interrupt you. You push back. Darden Cintron attempts to make everyone be quiet.
Okay. Is it your recollection that Trustee Mayers is allowed to spend several minutes on issues that interest her, and the president does not stop her?
I think that has occurred.
Okay. But you do, would you also say when I go on for a few minutes, she attempts to stop me?
At some point.
Okay. Do you recall the meeting this year at which the board wanted to hire Mary O'Neill to help with the transition of her replacement?
Vaguely.
Okay. Do you recall that the board went into executive session to discuss the issue and reached a consensus to appoint Mary to assist with the transition?
Yes.
Do you recall that after that conversation and other business in executive session, we came into open session?
I don't recall it, but it must happen before you can exit a meeting. You have to do that.
Right, okay. Do you recall that we then went back into closed session because I informed the president that there was an outstanding issue that we were supposed to discuss but had not discussed?
No.
Do you recall that at that meeting, we went back in to discuss Dr. Chase's pay raise?
I recall a discussion of Dr. Chase's pay raise.
Okay. Do you recall in the second executive session when we discussed the pay raise, do you recall how much time we spent on that?
No.
Do you recall that it happened pretty quickly?
No.
Do you recall an extended conversation about it?
Objection, Judge. The witness doesn't remember.
He said he does not recall how much time was spent. So sustained.
Do you recall, do you recall that after the discussion about Dr. Chase's pay raise, Ms. Mears again brought up the issue about Mary O'Neill?
Judge, objection. I'm not sure if we're in executive session here. I don't know whether privilege applies to this conversation, so I have to object.
Yes, clarify your question to make sure, Mr. Williams, you aren't talking about
Sure.
discussion in executive session.
Okay, I wasn't going to talk about substance, but I will rephrase. Do you recall a subsequent conversation about an issue that we had already discussed and agreed upon?
There have been instances in which there issues that we've been discussed and agreed upon have been brought up again.
Right. And do you recall that this particular issue was brought up again?
I do not.
You do not. Do you recall that it was Tracy Mears that brought it up?
Objection, Judge. He doesn't.
I cannot recall the issue, and therefore I cannot recall whether
Just a
it's Tracy Mears or
second.
not.
Mr. Warner, just a minute. Objection, Mr. Mahalan, go ahead. Asked and answered essentially.
Yes, and the witness said he doesn't know, but then he asked a follow-up question.
Yes, Mr. Williams, you have to move on if the witness says he doesn't recall.
Sure, Judge. Thank you. Just bear with me a second, Judge.
No problem.
David. Let's find the exhibit, I'm sorry. David, there came a time where after the December 17th meeting, you were concerned about Trustee Drogic's comment about Dr. Valenti's age.
That was prior to the December 17th meeting.
Right, thank you for correcting me there. But suffice to say, you had expressed concern about that.
Correct.
And you inquired of the president to ask the attorney if, given what you heard, were you required to, was the board required to file a report about that?
Judge, I'm
Correct.
gonna object to a line of questioning. This goes into an attorney-client communication that's not been part of the record yet. And I just want to be very careful. I don't know where we're heading, but I suppose I don't mind a yes or no question being asked if this question was posed to counsel for the board, but I'm going to object to substantive disclosure of the advice that may have been given and whatever follow-on communications may have arisen from that.
Mr. Williams?
I think Mr. Mulholland has entered that into the record, number one. Number two, we had a conversation about that and at a previous hearing, and what was allowed was that I was able to send, and I can't recall if it was Trustee Drogic or President Darden Centron. I was able to send the memo in question for them to discuss. And I would further go on to say that at the last session or in a subsequent session, Mr. Mulholland brought up the meeting in January in which I got there late around 9:40, and Trustee Drogic said that they discussed the substance of this memo.
Mr. Mulholland, do you want to respond to that?
It wasn't the substance of that memo, Judge. To the contrary, my point was that the memo was not at all germane to the events of April 7 and what Mr. Williams disclosed. It was an oral conversation by Attorney Melnick concerning the nature of the comment and whether it amounted to evidence of age discrimination, not about whether there was an obligation to report. And I think we're opening a can of worms here that will have no end. If Mr. Williams is going to make an argument that he somehow was obligated to report what he thought was discrimination and therefore was duty bound on the night of April 7 to make that disclosure in front of Ron Valenti, it's an absurd argument. And I certainly can't sit here and watch while he tries to cobble it together through a lay witness. It's inappropriate.
Well,
Let's
Mr.
bring
Wil-
back the attorneys and ask if they ever advised Mr. Williams that he had an obligation to report to Dr. Valenti what he disclosed on April 7.
I have,
Judge,
what, Mr. Williams, go ahead.
yes, Judge. Mr. Mulholland has just misapplied the record. The fact of the matter is, it was Mr. Warner's email who asked about the obligation of whether or not the board had an obligation to report. I've never said that, and for him to imply that or even explicitly say that is I don't want to use the word lie, but it's a lie. That's just not true.
You did just use the word lie, so
Yeah.
I would tell you to refrain from that.
Okay.
You can certainly make whatever argument you want. Mr. Mulholland's objection goes to, steering away from getting into testimony regarding the legal advice that was rendered. The last question that you asked is allowed. I'm going to allow the witness to answer that. But again, if you're going into privileged information shared from counsel to the board, then we're not going to allow that into the record. In terms of whatever arguments you want to make, whether or not they've been forecasted by Mr. Mulholland, you can make those arguments. That's what the last portion of this proceeding is all about, the closing, okay? So that last question, I'll allow the witness to answer. Reporter, would you please read that last question? It references the December 17th.
I just got it located, Judge. And you inquired of the president to ask the attorney if, given what you heard, were you required to, was the board required to file a report about that?
Okay, Mr. Warner, I'll
Could you
allow,
repeat that one more time?
would the reporter repeat that, please?
And you inquired of the president to ask the attorney if, given what you heard, were you required to, was the board required to file a report about that?
You can answer that.
The board was not required to file a report about that.
But you were the one who inquired about that.
Correct.
Thank you. So, David, let me ask you about the meeting of, I believe it was January 7th. And I believe it is board exhibit. Bear with me 1 second, David. I'm sorry for this. Board exhibit number 48. Could you put a board exhibit number 48, please? David, can you see this?
I can.
Do you recall us discussing, do you recall this exhibit being entered into evidence at the last session?
I recall that this has been entered into evidence.
And you recall the discussion about it?
Yes.
Do you recall at this meeting, that the question that you raised about our need to report what Ms. Drogic said it was unnecessary to make some kind of report based on what Ms. Drogic said about Dr. Valenti's age?
I recall that Dr. Valenti made a statement in closed session regarding his tenure. I recall that you were not there at the time. I recall that after he made his statement, he left the room. I recall that I then had my questions answered, and then you entered the room.
So your questions that you had answered, were your questions about the need for the board to report this behavior?
Yes.
Was the answer about, did the answer basically say there was no need to report?
We are allowed to report, but we are not required to report.
We are allowed to report, we're not required to report. Was there any discussion? Did the attorney say that the comments did not amount to discrimination?
Those were not my questions.
Those were not, okay. I'm sorry, did I interrupt you?
No.
Okay, so
I did not ask whether or not the comments rose to the level of actual discrimination. I asked whether if there had been discrimination, we were required to report it.
Okay, thank you. So the attorney never said this is not discrimination.
Objection, Judge. This is a critical issue and it's a leading question. I object. And it also is getting into the privilege.
May I, Your
Oh,
Honor?
it can be heard, Mr. Williams.
I'm sorry, did you say I can be heard or
Yeah,
the question
go
can be heard?
Of course, you can be heard.
Yes, so again, when Mr. Mulholland had Ms. Dragic as a witness, he specifically addressed and asked that question about whether or not, if the attorney said that that discrimination had occurred. So I'm just merely asking another witness basically the same question.
Mr. Mulholland, you want to respond to that?
If he wants to ask the same question of what this witness's recollection is, Judge, that's fair, but I don't believe it should be a leading question.
Rephrase your question, Mr. Williams.
Court reporter, can you read my question back to me, please?
So the attorney never said this is not discrimination.
So rephrase your question.
Okay, thank you. Did the attorney, David, did the attorney ever provide an opinion on whether or not Tanya's comments were discriminatory?
No.
Okay, thank you. I just have a few more questions. Bear with me 1 second, Your Honor.
That's fine.
David, do you recall the meeting that a number of the trustees had with Senate Majority Leader Andrea Stewart Cousins?
Yes.
Do you recall that you and I were there?
Yes.
Do you recall that Ashley Pineda was there?
Yes.
Do you recall that Tracy Mayers and Tanya Dragic was also there?
I think Tracy was late, but I think they were there.
Well, thank you for answering that. My question was going to be, did they arrive, did Tanya and Tracy arrive after the appointed hour of the meeting?
I remember that Tracy arrived after the appointed hour of the meeting because Tracy was going to be the one presenting. I don't remember Tanya, whether Tanya was late or not.
So do you recall then, so if I could ask the tech to put up board exhibit number 5. And if we could go to page 2. And in the subject of page 2 is recap meeting with Andrea Stewart Cousins. Would you agree?
That is the subject.
Right. Would you agree that we have 1, 2, 3, 4, 5, 6 people here, 7 people, including myself? Is there a possibility that if 7 people attended a meeting, there could be 7 different opinions?
Yes.
Thank you. Could you scroll up tech a little bit?
Which
And
area?
can you make it larger and just scroll the page up a little bit? Oh, okay, I think that was good. Okay. So, David, you were not a part of the meeting, the planning meeting for this meeting.
Correct.
Do you recall that it was the Government Relations Committee?
Yes.
And did you know that the Government Relations Committee had come up with an agenda and talking points for this meeting?
I believe I made the order of events was that I made a presentation to a group of legislators, including Andrea Stewart Cousins. And then the day before we were to meet, your group met and came up with a strategy. And
Okay. Thank you. Okay. So in my second paragraph here, I talk about Tracy, and as you've already said, she was going to be the presenter because she's the vice president and the president wasn't there. Can you please read that paragraph beginning specifically?
Just a minute. I want to strike the record as to the comment. She's the vice president and the president wasn't there. Again, the witness has to testify as to facts.
Sure. I'm sorry about that. Yes, thank you. So, David, can you tell us?
Judge, could I note my objection to asking this witness to read an email? He's already said he was not at the meeting. I'm not sure where this is heading. The document speaks for itself, Judge.
Mr. Williams, you want to be heard on that?
Yes, I can tell you where it's heading because Mr. Warner wasn't at the meeting, but he can either say yes or no. This correctly summarized what occurred. He can summarize. He can correctly summarize. He can opine that yes, this did or did not occur.
But he said he wasn't there, Judge.
Mr. Williams, if he was not at the meeting, then
I was at
he was at this
the meeting with the senator. I was not at the planning meeting. So he can't have me confirm what was done at the planning meeting, but he can confirm what happened at the meeting with the senator.
Okay, so understanding that distinction, Mr. Williams, then direct your questions to what happened at the meeting with the senator.
Sure, thank you. So I'll back up and ask this question first. David, was Antoinette at the meeting with the senator?
I do not believe so.
And in her absence, who led the meeting?
The vice president.
And does the vice president typically stand in when the president is not available?
Yes.
Thank you. So, Judge, may I have Mr. Warner read this paragraph?
The paragraph beginning with specifically?
Yes, just that paragraph.
Okay, Mr. Warner, read it first of all to yourself and indicate if this is what you recall occurred at the meeting which you attended.
All right, I've read the paragraph to myself. Do you want me to read it out loud now?
No, can you just confirm to me that this paragraph
Okay.
relates to the meeting which you attended rather than the planning committee meeting?
Okay, so the first clause, the VP Maris failed to deliver the monetary request as directed by the committee. I cannot opine on that. She
No,
asked the senator, what can you do with this
No.
for us? Yes.
Mr. Warner, just a minute. I don't want you to opine on anything. I want you to testify as to facts. But my question to you is, based on Mr. Mulholland's objection, you were at one meeting, you were not at the other one. I want to make sure that if you are testifying to something, it relates to the meeting which you yourself attended.
I cannot attest to any facts regarding what the directions of the committee were. I can attest to the "what can you do for us" comment. I believe that to be accurate. And I have no recollection about her pregnancy or any comments about her pregnancy.
Thank you. So David, let me just ask this question since, let me ask this question. During that meeting, do you recall that Vice President Mayers failed to deliver the monetary request that we, do you recall that she failed to deliver a monetary request?
I recall that my presentation on the day prior to your meeting had bollocksed had disrupted her ability to follow a preset list of requests, 1, 2, 3, that you guys had come up with. And therefore she was not able to function on script because the script no longer worked because I'd already tried to sell request number 3. So she couldn't go 1, 2, 3 anymore. So she appeared to just give up on that and just say, what can you do for us?
Okay. So David, if, would it be, if my recollection of let me rephrase. Okay, no, I don't have any other questions about that. Okay, thank you, David. Just bear with me a second. I'm going to ask the tech to bring up board exhibit number 23.
Please do so, Tech.
David, do you recall seeing that I shared this particular link?
I believe Antoinette may have forwarded this to me.
Okay.
Or to the board.
Right. And this particular link talks about Ray and Associates having to forfeit their fee because of their due diligence in the St. Paul Public School superintendent search.
Yes.
And I think you answered earlier about their subpar due diligence regarding our search.
Yes.
Okay, thank you. David, during the superintendent interview process, I added context to my questions.
Yes,
Did any other trustee add context to his or her question?
I think Tanya may have added context to one of her questions.
Right. Did Antoine, after the first candidate, did Antoinette ask me to stop adding context to my question?
I believe she did.
Did she ask Tanya to stop adding context to her question?
I'm not sure that she did. I don't remember whether it was a generic caution to everybody or if it was directed specifically at you.
Did I stop
Did
adding
not call out Tanya Drudge.
Okay. Did she call me out?
She may have. I do not recall.
Okay. Did I stop adding context to my question?
No.
Did Tanya stop adding context to her question?
I do not recall.
Okay. In one of the questions that I had, it had to do with the building project. Do you recall that? Let me rephrase. My question, do you recall that one of the questions that I had was, could you basically go over with us how you would manage a building project?
That sounds familiar.
And as part of that question, did I add context about a current board member who worked to defeat the bond proposal that we put up in 2019?
I recall that.
Was that accurate?
Yes.
Did I ever mention anybody's name?
You did not tell which board member had worked to defeat the bond.
Okay, thank you. Were we advised by, never mind, I'll withdraw that question. Judge, I have no other questions at this time.
Mr. Williams, Mr. Mulholland Cross?
Judge, just a few questions. If I could ask the tech to bring up Board Exhibit 47, which are the minutes from the February 23, 2021 board meeting.
Please do so.
If you could please expand the bottom third, beginning with the header that reads reconvene in open session. Mr. Warner, do you generally recall that it was after an executive session that the board went back out and voted publicly to appoint Dr. O'Hara as the new superintendent on February 23rd?
I do recall that.
The executive session, if we could, the tech could please go up to opening items and expand that section of the center right there. Yeah, down to reconvene an open session. Sure, perfect. Thank you. So by this document, you were in executive session from approximately 6:25 to 9:35, 3 hours and 10 minutes, give or take, right?
Okay,
That's accurate, isn't it, to the best of your recollection?
close, it's close, yeah.
You mentioned when Mr. Williams was questioning you, some things that came out about what he referred to as subpar due diligence. That was during this executive session, right?
I believe so, yes.
And that was when Mr. Caldwell was questioned about whether he had withheld information that might have been relevant to the analysis, right?
Yes,
So all those things that Mr. Williams questioned you about as having not been brought out previously were out and on the table and now known to the full board by 9:34 p.m., right?
yes.
So let's look what had happened at 9:34. If the tech could go down to the bottom third again, and you're going to have to also show simultaneously page 2, which contains the outcome of the resolution. So in executive session, I want the witness to be able to see the resolution and the outcome.
Mm-hmm.
So Mr. Warner, armed with all the knowledge that Mr. Williams explained had come out during the executive session, armed with that knowledge, the resolution was put before the board, right? To appoint Dr. O'Hara.
Correct.
And the majority of the board approved the resolution 5-1-1, right?
Correct.
I don't have any other questions, Judge.
Anything based on that, Mr. Williams, which you have not already asked?
Yes. So if the tech could put that back up again. And that's a good spot right there. So David, so 5 board members appointed, 5 board members voted to appoint Dr. Hara superintendent, even though they found out at this meeting that, let me rephrase. Five board members voted to appoint Dr. O'Hara in spite of the fact that there was material information withheld by the search consultant.
Yes.
No further questions.
Anything, Mr. Mulholland?
Yes, Judge. And Mr. Warner, you would agree that is the collective will of the majority at that point to appoint Dr. O'Hara by a margin of 5-1-1, right?
Yes.
And the board operates by a majority?
Correct.
Does Mr. Williams' vote count more than other votes, Mr. Warner?
No.
You all have an equal vote. Isn't that the way it works? 7 board members appointed by the community, each with a single equal vote?
You are correct.
Nothing else, Judge.
Mr. Williams?
Yes, Judge, did my pointing out of the poor due diligence by the search committee alter the will of the board?
No.
So 5 members, despite learning that material information had been withheld, decided to move forward with Dr. O'Hara.
Okay, that's been asked and answered so many times.
Sure, thank you.
Anything
Thank
further,
you. No, nothing further.
Mr. Mulholland?
Judge.
No?
No, Judge.
Okay, thank you. Mr. Warner, thank you for your testimony. You're finished. then.
Thank you.
Mr. Williams, any further witnesses?
No further witnesses, Judge.
Okay, Mr. Williams, then I want to just be clear for the record, you are intending to not offer testimony yourself.
I am not offering testimony.
Okay, then you rest.
The defense rests.
Okay. Mr. Mulholland, any rebuttal?
No, Judge.
Okay. Gentlemen, then we are concluded in this stage of the taking of evidence. We then move to the last stage, which is the closing argument. And Mr. Williams, this is where you get to tie all the facts together and make whatever argument you wish, as does Mr. Mulholland. Do you desire to do this, gentlemen, verbally, or do you want to file briefs? Mr. Mulholland?
I think it would be beneficial to file a brief, Judge. I'm prepared to go either way, though.
Mr. Williams?
I prefer to file a brief.
Okay, then we will save your arguments for your written briefs. Typically, I order those to be due about 30 days after the transcript is rendered, and I provide you with a date certain of that once I receive my copy of the final transcript. So we'll probably be looking to sometime in July for the final brief. Is that consistent with what your availability is in terms of your schedules?
Yes, Judge.
Yes.
Okay, all right, so then the record is closed. I will notify you of a date certain for the due date of briefs once I receive my copy of the transcript. You can both file them with me, and once I receive both, then I will direct you to file them with each other. So you can share your briefs. Okay, if there's nothing further, then thank everybody. My thanks to everybody for your participation. This was a very efficient virtual proceeding, and I commend everybody for that. Mr. Williams, thank you, and Mr. Mulholland, thank you for your good organization and participation.
Thank you, Judge.
Thank you, Judge.
Okay, thank you. We're done. Have a good
Thank you,
evening.
everyone.
Good night, everyone.
Good night.